Subcommittee will come to order. Without objection, the chair is authorized to declare a recess of subcommittee at any time. Without objection, members of the full committee, not members of the subcommittee, are authorized to participate in today's hearings. Without objection, all members will have 5 legislative days within which to submit additional written questions for the witness. You submit those to the chair, they'll be forwarded to the witness, and we ask the witness to give us a prompt response. Without objection, all members will have 5 legislative days within which to submit extraneous material to the chair for inclusion in the record. I remind members that written questions and materials for the record should be submitted to the email address provided to your offices. This hearing is entitled Oversight of the SEC's Division of Enforcement. I recognize myself for 4 minutes. There is nothing more important for this subcommittee to do than oversee the SEC. I look forward to the full committee bringing the chair of the SEC before the full committee. I would hope that that would happen either at the subcommittee level or at the full committee level several times each year. But oversight of the SEC is also enhanced by bringing before us the division director of the largest division of the SEC. The Securities and Exchange Commission oversees $100 trillion in securities investments and reviews disclosures of 7,400 public companies, including more than 4,000 exchange-listed public companies. The SEC has an annual budget of $2 billion, supporting 4,500 employees across both the headquarters and the 11 regional offices, the most important of which is now in my new district in Los Angeles. The agency's largest division is the Enforcement Division, with some 1,366 employees, representing a quarter of the SEC staff. The division is responsible for enforcing our securities laws. In 2021, the SEC filed some 434 new enforcement actions, representing a 7% increase. As the chair of the SEC, Gary Gensler, pointed out, the purpose here is to discourage misconduct before it happens. Today, the division faces new challenges in the form of cryptocurrencies and other digital assets. The combined value of these digital assets hit $3 trillion at a peak, from which it has declined. In response in 2017, the SEC established a crypto assets and cyber unit within the Division of Enforcement. That division has brought some 80 enforcement actions related to fraudulent and unregistered crypto asset offerings and platforms, resulting in monetary relief totaling $2 billion. This is by far the most of any federal or state regulatory body. Obviously, there have been recent downturns in the value or purported value of crypto assets. In particular, their enforcement actions depend upon the definition of the word security under a relatively ancient Howey test. The division has determined that XRP is a security and is going after XRP, but for reasons that I'll bring up in questions, has not gone after the exchanges where tens of thousands of illegal securities transactions were occurring. The division faces a number of longstanding challenges. Today, we're considering a number of important bills that are listed for all of the members of this subcommittee and are being considered in this hearing. There is no federal statute defining insider trading. I know Mr. Himes has a bill designed to do just that. And, of course, the Newman decision narrowed the definition somewhat of insider trading. Another issue for us to confront is the maximum civil monetary penalties, which some bad actors simply regard as doing a cost of doing business. Recent decision in the Fifth Circuit has called into question the whole use of using administrative law judges, which is the primary method of enforcing our securities laws. The court found a number of problems. Some are constitutional and would require a change in practice if that court decision, which is now in appeal to an en banc review, is upheld. But other concerns of the court are about the inadequate standards that the Congress has put into the statute, and we need to correct those by legislation probably even if the court decision is successfully appealed. Finally, we're looking at the SEC's use of waivers where bad actors admit to wrongdoing but then don't face the full penalties. With that, I recognize the ranking member for his 5-minute opening statement.
Thank you, Mr. Chair, and welcome, Director. Glad to see you here. And interestingly enough, it's been 4 years since the Director of Enforcement was sitting as you are today. 4 years since this subcommittee had provided oversight for your division. 4 years since members of this committee on both sides of the aisle were given the opportunity to raise concerns over enforcement actions taken by the SEC, and I think it's safe to say this hearing is long overdue, and it is a key element. I mean, it's titled Oversight of the SEC's Division of Enforcement. It is a key element of what this subcommittee's jurisdiction is, and it's been missing. And I appreciate the efforts of the chair, who has been advocating, at least privately with us, about having yourself and having other directors, and frankly, even having the chair. But this is not going to stop as a request from myself, and I think from other members of this committee. This is our constitutional requirement and duty is to act as the oversight for the administration at all levels. So, the SEC has happened and gone a long way in the last 4 years. In the 14 months since you were sworn in, since he was sworn into office, Chair Gensler has charted a path for the SEC unlike any other time in its 88-year history, from an agency that has a mission to protect investors, maintain fair, orderly, and efficient markets, and to facilitate capital formation. Those three things, let me repeat that. Protect investors, we all agree on that. Maintain fair, orderly, and efficient markets, we all agree on that. But to facilitate capital formation, that seems to have been something that has fallen off of his radar in many ways. And he's embarked on one of the most ambitious rulemaking agendas in our modern era since we've had the SEC. And to put this in perspective, the SEC's past 3 chairmen issued half as many proposals in their first 14 months compared to the current chairman. The flurry of activity is evidence that the rapidly evolving enforcement and regulatory landscape at the SEC is an indicator of things to come. I don't think it's going to slow up. In the past, increased enforcement activity at the Commission has signaled that they will act aggressively, pressing the boundaries of their enforcement authority. So of note, it looked no further than the SEC's announcement this past May to nearly double its crypto enforcement unit. While the Commission does not intend to provide any clarity surrounding the application of securities laws to digital assets, the unit plans to focus on violations related to crypto asset offerings. So crypto asset exchanges, crypto asset lending and staking products, decentralized finance platforms, non-fungible tokens, stable coins, et cetera, et cetera. So it's worth mentioning that of the 63 items included in the agency's rulemaking agenda this past spring, exactly 0 pertain to digital assets. In addition to the division's proactive enforcement efforts, your words, not mine, the SEC continues to use its own administrative law judges to adjudicate enforcement actions, a controversial decision that has been used increasingly over the past decade. In a recent court decision, the Fifth Circuit Court of Appeals noted that Congress has unconstitutionally delegated legislative power to the SEC when it allowed the Commission to decide when to use these ALJs. And coupled with the SEC's own admission earlier this year that there was a control deficiency related to the separation of the SEC's enforcement and adjudicatory functions with serious ramifications regarding the fairness of prior SEC enforcement actions for the party subject to those actions. So finally, I would be remiss if I didn't mention the one person who is not here this morning, the chair of the Securities and Exchange Commission, Chair Gensler, but I know he is paying attention, so Chair Gensler, while I appreciate you allowing the Director Grewal to come in before the subcommittee, I can't help but mention your absence and request your attendance. So, Mr. Chair, I'd like to submit two letters from Ranking Member McHenry and myself, one dated October 6th, 2021, and the other May 5th of 2022, requesting Chair Waters to hold a hearing with all 5 of the SEC commissioners. It's now been nearly 3 full years since we last heard from the commission, and since then, Chair Ginsler has proposed 23 rules that await adoption. I think it's long overdue. So, Director, let me caution you with this last word. We should not evaluate the true effectiveness of the regulatory agency or its enforcement program solely based on how many headlines it can generate. That is true of any federal or state regulatory agency in the country, and it's certainly true for the SEC, and I look forward to hearing from you on the impact on our capital markets. With that, I yield back.
Thank you. I now recognize the chairwoman of the full committee, the distinguished Ms. Waters.
Thank you, Chair Sherman, for holding this important hearing. Between last year's meme stock events, the implosion of SPACs, and this year's catastrophic crypto crash, the life savings of ordinary Americans who were drawn into risky and fraudulent investment schemes have been lost. The work you do every day to go after scammers and those who peddle unsuitable financial products is critical. It is refreshing and promising to have as our witness today Director Grewal, an enforcement director who has fought for years as an attorney general on behalf of the people of New Jersey. Director Grewal, welcome to the committee, and thank you for your years of public service.
Thank you. Today we welcome the testimony of our distinguished witness, Mr. Gurbir Grewal, who is Director of the Division of Enforcement at the Securities and Exchange Commission. Previous to that, he was Attorney General of the state of New Jersey. Director Grewal, you're reminded that your oral testimony is limited to 5 minutes. You'll see the timer, you know the drill, and without objection, your full written statement will be made part of the record, and without objection, the letters referred to by the ranking member will be made part of the record. Director Grewal, you are now recognized.
Chairman Sherman, Ranking Member Huizenga, Chairwoman Waters, and members of the subcommittee, good morning, and thank you for inviting me to testify today on behalf of the SEC's Division of Enforcement. Throughout its 85-year history, the SEC has stayed true to its 3-part mission of protecting investors, of maintaining fair, orderly, and efficient markets, and facilitating capital formation. Central to that mission is the work of the Enforcement Division. Since my appointment, I've been amazed by the talent and the expertise of the division staff, and I'm privileged to call them all my colleagues. Each year, the Commission brings hundreds of enforcement actions and obtains meaningful relief on behalf of the investing public, and fiscal year 2021 was no exception. Despite the challenges of the global pandemic, we filed 434 new enforcement actions covering a broad range of violations and representing a 7% increase over the prior fiscal year. Yet, many Americans' trust in our financial markets and institutions is at near historic lows. While there's no single cause for that decline, part of it is certainly due to repeated lapses by large institutions and gatekeepers, and the perception by many that they are not being held accountable. It's critical that we at the Enforcement Division do our part to restore that trust and to increase accountability. And I believe that's best done by focusing on 3 things: robust enforcement, robust remedies, and robust compliance. Robust enforcement means investigating and litigating every type of case within our remit with a sense of urgency. It also means keeping pace with new areas of importance for investors, as well as continually evolving risks. That's one reason we recently added 20 positions to our crypto assets and cyber unit. The expanded unit will leverage the agency's expertise to ensure investors are protected in the crypto markets and against cyber-related threats. Robust enforcement also means focusing on gatekeepers, such as compliance officers, accountants, and attorneys. We can't be everywhere, and gatekeepers are often the first lines of defense against misconduct. So when they fail to live up to their obligations, their professional responsibilities, and when they give cover to corporations or executives engaged in misconduct, investors and market integrity suffer and trust deteriorates. A second component of restoring trust is seeking robust remedies in our cases. Put simply, the remedies we seek must both punish wrongdoers and deter those violations from happening in the first place. To ensure that's the case, we're constantly assessing whether penalties in prior comparable cases have sufficiently deterred the misconduct at issue. Where they haven't, especially with recidivists, we'll seek stiffer penalties. Robust remedies must also include obtaining all appropriate prophylactic relief available. Relief such as bars, suspensions, conduct-based injunctions, and undertakings. Relief which directly protects investors and market integrity by preventing violators from engaging in future misconduct. And while most of our cases will continue to include no admit, no deny settlements, we'll seek admissions from wrongdoers in certain cases, especially in cases where heightened accountability and acceptance of responsibility are in the public interest. Finally, robust compliance is also critical to restoring trust. We're in a time of rapid and profound technological change. Public companies and other market participants need to think rigorously about how their specific business models and products interact with both emerging risks and their obligations under the federal securities laws. And they must tailor their internal controls and compliance practices and policies accordingly. In short, they must work to foster a culture of proactive compliance and responsibility. To ensure that's the case, we're pushing enforcement actions that go to the heart of robust compliance efforts, including actions targeting wholesale record-keeping failures by firms that have either promoted or failed to rein in off-channel communications. All of what I've described requires resources, and the number of enforcement employees has decreased over time. We face significant and mounting challenges as described in more detail in our budget request and in my submitted testimony. At the same time, many of our investigations are becoming more and more difficult as fraudsters find new ways to communicate. Our FY23 budget seeks additional staff to enable us to meet these mounting challenges and to maintain an effective investigative capacity and deterrent presence for the benefit of our markets and investors. I'm confident that with adequate resources and by emphasizing robust enforcement, remedies, and compliance in our work, we'll be able to meet future challenges, achieve our tripartite mission, and do our part in restoring public trust in our financial markets and institutions. Thank you for inviting me today, and I look forward to answering your questions.
Thank you. I now recognize myself for 5 minutes. I'll point out that Chairman Gensler came before our full committee twice last year. He'll be coming before us, I believe, later this year. More is better, but we are certainly doing our job. The ranking member points out that the SEC has a number of regulatory projects. I commend them for having those projects because, as the ranking member points out, we need clarity. If anything, we need another project, and that is to define a security, particularly with regard to the digital world. I would also point out that investor protection is the very best thing we can do for capital formation. When we it may be a hassle for the individual issuer, but when we build a system where investors are confident, that's what causes people in this country to invest in growing businesses. Now, the first question relates to spring-loaded stock options. The SEC has analyzed these as to whether they are insider trading. I'd like you to focus on whether they are, in effect, a fraud on shareholders in their annual filings. They file statements saying that they have a stock option plan in which stock options are going to be granted at fair market value on date of grant. Well, if it's 6 p.m. before the next day you're going to make the big announcement, and you look at the market price with the market not knowing about your upcoming big announcement, you can say, well, that's the market value because that's what ignorant shareholders bought and sold the stock at. But the directors and compensation committee, they got approval for granting the stock option at fair market value. They know the fair market value is going to skyrocket the next day because the big announcement is coming. Why are you not enforcing against spring-loaded stock options when shareholders are defrauded when they're told that the option will simply give the grantee a share in future appreciation after option grant date?
Thank you for the question, Chairman. While I can't comment on specific investigations that may or may not exist at this moment, I would agree that your hypothetical raises serious fraud concerns. The facts that you've laid out would implicate accounting issues on how those options are being accounted for, and they would implicate disclosure issues. As you mentioned, what did the issuer disclose in its filings? What did it say about how it would...
I would hope you would go back and look at the many instances of spring-loaded stock options, particularly when in the headline, the shareholders who are asked to approve these plans or made knowledgeable of plans told that it's going to, the option exercise price is going to be fair market value on the option grant date. And then they may define fair market value as what the market closed at, which is usually true, except the market closed right before the big announcement. I want to move on to another question. You've gone after XRP because XRP is a security. But you haven't gone after all the major crypto exchanges that process tens of thousands, if not far more, transactions. If XRP is a security, and you think it is, and I think it is, why are these crypto exchanges not in violation of law? And is it enough that the crypto exchanges have said, well, having committed tens of thousands of violations in the past, we promise not to do any more in the future? Is that enough to get you off the hook for enforcement?
So, again, I can't talk about what matters we're looking at or not looking at. We have brought exchange cases. We brought one last year against Poloniex. I share your concerns that if securities are...
It's easier to go after the small fish than the big fish. But the big fish operating the major exchanges did many, many tens of thousands of transactions with XRP. You know it's a security. That means they were illegally operating a securities exchange. They know it's illegal because they stopped doing it, even though it was profitable. So if they know it's illegal, and you know it's illegal, and I know it's illegal, I hope you'd focus on that. And then finally, we have Tether, which is broke a money market mutual fund in every way. It broke the buck. Can you, I realize you're reluctant to talk about individual matters, but can you tell us why you went after Terra but not Tether?
Again, it would be inappropriate for me to comment on who we're going after or not going after, but I understand your concerns, and we've added resources to our crypto assets unit to look at issues that put investors at risk, including the issues you've raised in your questions.
Add fortitude and courage as well. You're going to have to take on some cases that you're not certain of winning. I now recognize the gentleman from Michigan, Mr. Huizenga, for 5 minutes.
Thank you, and Director Grewal, like I said in my opening statement, we want to see more of you, not less of you. I will note to the chair that, yes, the chair of the SEC was in front of this full committee in October. Look at what's happened since October with the rulemaking, the number of proposals, et cetera, and unless there's some secret plan to make sure he's in September, he's not going to be here, maybe not even for the rest of this Congress, so that will be over a year since we've seen the director. So, I'm sorry, since the chair. So, Director Grewal, concerned about a couple of things, and I'm going to try to hit this quickly. Unprecedented attempts by the SEC to slip drastic market-changing interpretations of securities laws into otherwise routine enforcement cases, and two, the lack of internal consistency when it comes to the SEC's own ideas about basic foundational elements of market regulation. In a recent case, the SEC, rather than relying on decades of existing case law and legal precedent, presented a case in which it defined a, quote, dealer as, quote, any business that purchases and sells securities for its own account, close quote. So if I'm interpreting this correctly, it quite literally means that every market participant in the country, which means under the SEC definition, regardless of their business model or current regulatory regime, they would somehow now be subject to a widely different and inappropriate, in my opinion, regulatory framework. That quickly, overnight. So, and that's not all. At the same time, in the same SEC, there's a controversial proposal underway in which the SEC is attempting to dramatically expand the definition of this core term, dealer, but this time, a wholly different manner than how your enforcement team defined the term. So two different definitions being presented by the same SEC are in fact wholly inconsistent with each other. So it seems to me that the SEC is frankly brazen about it and thinks that it can rewrite the most basic of the elements of securities law whenever it wants to fit whatever purposes it needs at the current moment, with no regard to the effect on markets, the economy, or even internal consistency. And I'm a guy from Michigan, so I think in car terms. All right, this is a little like we're asking people to build a car, but we won't tell them what the speed limit's going to be. We won't want to tell them what the car should or shouldn't do, what the safety products ought to be on it. But we're going to determine that later, and we're just going to mail you a ticket for speeding. Well, we've got a responsibility to set speed limits and/or then to make sure that there's a consistent approach and application of that. So could you please illuminate me, what is this approach?
So thank you for that question, Ranking Member. With respect to the enforcement action that you referenced, that's a litigated matter, and we're confident that our position will survive scrutiny in that litigation. We've succeeded in other courts.
How about the inconsistency of it?
I can't speak to the rulemaking that's being done by the rulemaking divisions, and I think it's in a different context, so I'd refer you to my colleagues in those divisions who are responsible for that rulemaking.
Well, if we could get them here, I'd love to ask them. All right, so I want to return to something I brought up during my opening remarks about the ALJs, the administrative law judges. As you know, the SEC announced in April that they had identified a control deficiency related to the separation of its enforcement and adjudicatory functions within its system for administrative adjudications. To quote an article from the Wall Street Journal, quote, "It's the equivalent of a party in litigation having access to a judge's briefs from her law clerks," close quote. So given the scrutiny that the SEC has received over the use of their ALJs, I find this breach very concerning. Quickly, Director, can you assure members of this committee that the cases brought before an ALJ during that time of the breach were fair and fairly adjudicated?
So again, with respect to the breach, as soon as that breach was discovered, it was reported, it was publicly reported, and the matter's under investigation right now internally. But importantly, no enforcement division personnel were found to have access to those materials. It was simply that there was some permissions that allowed people to do so, but they were not accessed.
What gives you confidence? So has there been an investigation to determine that?
It's underway right now, Ranking Member.
So then how can you say that there was no breach? You actually don't know if the investigation's still going on.
Excuse me, I'm sorry to talk over you. In the announcement that the commission made, again, it's not being handled by my division. It's being independently investigated, but in the preliminary announcement, it was indicated that the materials weren't accessed. The investigation is going to cover how this lapse happened in the first place.
Has the SEC Officer of Inspector General reviewed this incident?
I would direct you to the Office of Inspector General. I'm not aware of what they're looking at or not looking at.
Well, I will be following up with some additional questions written as well, but underscores the importance of this, so I appreciate it. Thank you.
Now recognize the gentlewoman from California and chairwoman of the full committee, Mrs. Waters, for 5 minutes.
Thank you very much. Director Grewal, as you know, I've been focused on the problems associated with the lack of clear fiduciary standards for broker-dealers going back to the days when we were debating and drafting the Wall Street Reform and Consumer Protection Act after the financial crisis. I continue to believe that brokers providing investment advice need to clearly put the interests of their customers ahead of their own. This fiduciary standard is the gold standard to which all financial professionals who offer personalized advice to investors must adhere. Former SEC Chair Clayton, despite opposition from investors, approved the flawed regulation best interest, or Reg B1, calling something best interest doesn't make it so. For example, it relied excessively on disclosure to cure deep conflicts of interest problems. It allowed brokers to place their interests at par with that of the investors. Under Chair Gensler's and your leadership of the Division of Enforcement, the SEC for the first time enforced Reg B1. The case you brought forward showed that between July 2020 and April 2021, a firm and its brokers recommended and sold certain bonds to senior investors with limited financial wherewithal. While the issuer of the bond had clearly stated that the bonds are high risk and suitable for those with substantial financial resources. I can't imagine only one firm or a handful of brokers are engaging in this kind of practices and harming investors. Director Grewal, I know you can't talk about specific cases, but please do describe your experience in enforcing regulation best interests. Also, please address how, if at all, the broker-dealers have changed their practices. How are they better managing conflicts of interest? For example, do they offer the kinds of products and get paid at the same level that they need to do to prior to Reg B1?
Thank you for the question, Chairwoman. As you know, Reg BI became effective on June 30th, 2020. And after it became effective, there was a period of educating the market, and then our Division of Examinations went and conducted exams with a priority focus on looking at Reg BI compliance. That examinations process yielded a number of referrals, including the case you referred to, which is our first Reg BI action. It's a litigated action against a broker-dealer and 5 of its registered reps for selling highly illiquid debt securities to elderly retirees where it didn't fit with their investment profile. So that matter will be litigated. There are other referrals. Exams in its 2022 priorities has also indicated that it will be going out to look for compliance and to answer the questions you raised. Is it having its intended effect? Is it changing behavior? Are broker-dealers addressing conflicts of interest? And so it remains to be seen, but it's my hope with enforcement actions, with education, and with compliance that it's having its desired effect in the market.
Thank you very much. Director Grewal, as you know, nearly 2/3 of capital raised through our capital markets nowadays is done under various exemptions of the securities laws. These securities are not registered with the SEC, and investors in these securities, including pension funds, university endowments, foundations, and other large funds, do not benefit from the protections provided by the securities laws and the rules of the SEC. For example, investors often do not have access to audited and timely financial statements of the issuer or benefit from certain conflicts of interest provisions that apply to brokers that market these unregistered securities. Separately, but related, I'm also concerned that foreign issuers, including foreign hedge funds and private equity funds that raise capital in the United States, take advantage of these exemptions, and I'm concerned that U.S. regulators don't know who invests in these funds or where these funds themselves invest. Sherman and I have been working on legislation to increase transparency into this exempt offerings market. In the American Competes Act that the House passed earlier this year, there is a provision that would require issuers of exempt offerings to provide basic level of information to the SEC, including the beneficial owner of the fund and which country the fund intends to invest the proceeds of the offering. So I'm over my time at this point, and you don't have to respond to this right now, but I will be getting to you to talk about this issue, and I yield back the balance of my time.
Thank you. I now recognize the gentlewoman from Missouri, Mrs. Wagner, who for 5 minutes.
I thank you, Mr. Chairman and Ranking Member Huizenga. Director Grewal. Director Grewal, the SEC is expected to finalize its proposal on mandatory climate disclosures in the coming months. Issuers will be required to disclose very detailed and scientific climate-related data, possibly including data on downstream Scope 3 emissions, such as production and transportation of goods, employee commuting, and a host of other indirect emissions. Operationally, sir, how do you plan on handling enforcement cases involving an issuer's disclosure of its Scope 3 emissions?
Thank you for the question. Again, the rulemaking process is being run out of different
I'm talking about the
divisions.
enforcement.
Yeah, I'll speak from an enforcement perspective. We'll take the same approach we've taken to date. We know that ESG and climate issues are important to investors. We know that issuers are making statements about their climate risk already, and we know that investment advisors are marketing ESG funds. So we brought greenwashing cases when they breached their fiduciary duty on the advisor side, and we brought cases against issuers, most recently a litigated case against Brazilian issuer Vale for lying about its ESG policies. And so it's the same thing. If we find that sort of deceit in their statements, we'll bring cases.
But how will the SEC verify whether the issuer has misstated its Scope 3 emissions?
So again, I can't speak to the climate
From an
rulemaking,
enforcement standpoint.
but I'll give you how we're doing it in our enforcement actions. We're relying on experts in our litigated matters.
Experts. Really? Is the SEC an expert in climate policy?
We've retained experts in our case to
You
help
have?
us litigate that matter, yes.
What statute provides the SEC with the direct authority to regulate climate change?
In the litigated matter, there are anti-fraud violations of the federal, violations of the anti-fraud provisions of the federal securities laws. That's the theory in the litigated case.
And you say the SEC has experts on staff to address climate change?
Again, I can't speak to the rest of the SEC.
But you just did. I'm just asking, do they have?
I'm just talking about my enforcement division, and the people we've retained in that particular case are
You
experts.
have experts.
We've retained them in the litigation, yes.
How will the SEC recruit and hire qualified staff who are both experts on climate change in your purview and securities law disclosures?
So our attorneys and investigators are the experts on the securities laws, and we consult with experts in our investigations and in our litigation, regardless of the subject. So in the particular example I'm sharing with you, we rely on experts on the types of issues that are
Perhaps we need to
involved in
bring
that
those, quote, experts on climate change in the SEC before this committee. Director Grewal, when it comes to enforcing the SEC's ESG disclosure rule, how do you envision determining whether a fund has incorporated ESG factors into its investment selection process when the SEC has not defined and likely cannot define just what those factors are?
Again, I don't want to speak to the rulemaking. I'd refer you to the
I'm not
director
speaking to the rulemaking. I'm
investment
saying
man-
there is no definition. How do you do enforcement?
So the tools we have, you're talking about advisors. We brought a case recently against BNY Mellon for misstating their ESG practices. They said they were conducting a ESG review before making certain investments, and it turns out they weren't abiding by the processes that they have
Reclaiming
laid out in
my
their
time, sir.
disclosures.
Just how are these funds expected to know what the letters ESG even mean without a clear definition in the proposed rule? And how will the enforcement division know what the letters E, S, and G mean without a clear definition?
Again, in the advisor space, in that particular case, we alleged a violation of the anti-fraud provisions of the Advisors Act. We alleged a breach of the advisor's fiduciary duties because they misstated to the investing public what they were doing when it came to how they were
Has
reviewing
the
investments.
SEC put out a definition of ESG?
Again, I think that's what the rulemaking process is.
But you
going to
can't
address.
enforce something that's not defined, sir.
You can enforce, Representative Wagner, lies. When an advisor lies about what
Lies.
it's doing,
Lies when they don't even know what the clear definition in the proposed rule is. You know, we really need some answers on this, Mr. Chairman. I hope that we could bring in some of these so-called SEC experts. You know, I'm highly disappointed in the lack of answers and transparency today. I yield back my time. Thank you.
Thank you. We now recognize the gentleman from Georgia, Mr. Scott, who is also the chair of the House Agriculture Committee, for 5 minutes.
Thank you, Chairman. I appreciate that. And welcome, Director Grewal. But first, I want to set the record straight. This whistleblower program has been very, very effective. And I want to commend Chair Gensler and our SEC for the excellent job they're doing. The program has brought violations using whistleblower information. It has resulted in $5 billion in monetary sanctions, rewards totaling $1.2 billion. The program deters crime, it places fraudsters in jail, and it protects the integrity of our capital markets. Job well done. Now, I want to make sure that you have the proper funds, the money to continue to do the fine work that you're doing. Can you guarantee, my first question is this, Mr. Grewal, can you guarantee that the whistleblower program is now properly equipped, properly funded to process the current number of complaints with the money that you have and hold these fraudsters accountable?
Thank you, Representative Scott, for that question. Our whistleblower program is critical to our enforcement program. The information that whistleblowers provide about wrongdoing sometimes allow us to bring actions that we otherwise wouldn't be able to make. We have dedicated more resources to more timely resolve whistleblower applications. The numbers of applications are increasing, but we're investing the resources to make sure that the program remains the success that it is.
Well, let me ask you this now. I think that you and the SEC are requesting for your budget for fiscal year 2023 an 8% increase over the FY22 budget. So my question is, I understand that this will go towards an increase of 12.5 new positions for the enforcement division. Is that correct?
I think it's 125.
125. 20 new positions for crypto assets. Is that correct?
I think
And
that,
your cyber union.
I believe that's accurate.
And 90 new positions for the Division of Examinations. So, can you share with us how many of these enhanced staffing increases will be solely focused on the whistleblower program?
So I think it'll depend, Representative Scott, on what we ultimately receive as part of the budget process, but I could assure you that we have put resources in already. We continue to put people in on detail, and we continue to find ways to give them the resources they need to do their work, but it is a priority for us, and we try to balance that with all of our other priorities.
So you're telling us that this will be adequate funding for you
If we
to
receive,
continue?
yes.
All right. Now, let me briefly discuss the SEC's recently proposed amendments aimed at enhancing the rules governing its whistleblower program. The first proposed amendment would allow the SEC to pay whistleblower awards for actions brought by other entities. The second amendment would uphold the SEC's authority to consider increasing the dollar amount of an award, but not lowering it. Why do you believe, Mr. Grewal, that adopting these changes is critical to continuing to protect our whistleblowers?
The changes you discussed, Representative, I think are important in recognizing what whistleblowers bring to our investigations, that it's not just the SEC sometimes, but also parallel DOJ investigations, parallel investigations by other regulators that result in recoveries that should be considered in the process when we're determining what a whistleblower award is.
Thank you again, Director Grewal. My time has expired. Continue to do the great job that the SEC is doing with this vitally important and needed whistleblower program.
Thank you.
Thank you. Chair has been advised that there'll be votes on the floor sometime between 11 and 11:30. My hope is that we'll be able to conclude the hearing before we actually have to cast votes. And I'll now recognize Mr. Hill from Arkansas, 5 minutes.
Did he call on me? Okay. I didn't hear you say my name. Thank you, Mr. Chairman. Yeah.
From Arkansas.
Yeah, thank you. Well, Director Grewal, thanks for coming before us today, and I want to follow up on a couple of comments from Mrs. Wagner's questions. In the BNY Mellon enforcement case on greenwashing, can you share with the committee who the experts were that your litigation team consulted with on that case, or did you have any in that particular case?
That's not the investigation I was referencing.
You were talking about the Brazilian dam situation?
That's right.
Yeah, okay. Well, let me turn to BNY Mellon. So the allegation there is they said they had a process by which they determined if companies were eligible to be in an ESG fund, and in your view, they just didn't follow it, so they were misleading. Is that a fair assessment?
That's what they admitted to as well.
Yeah. And so that would tell me that you've got all the authority you need as it relates to protecting investors in the mutual fund ESG arena, using simply the power you have now. Is that fair? You can go in and make a judgment if someone's misleading in advertising, or either at the financial advisor level or at the fund sponsor level. Is that fair?
I would agree that the anti-fraud provisions that we have that allow us to bring these cases are adequate. Again, the rulemaking is not my division, but what the rulemaking will help with is putting all those disclosures in a consistent, comparable format that would allow us to more easily further our investigations.
Yeah. So I've been looking at the proposed rule and reflecting on it, on how that might provide clarity if you were then going to pursue, an enforcement case. And so a couple of comments on that topic. Have you read the financial disclosure task force that was chaired by Mark Carney and promoted by Mike Bloomberg? Have you read that 2017 document?
I have not, Representative.
Because in it, it outlines many of the things that I think Chair Gensler and some other members of my colleagues on the other side of the aisle say are very important. And one of those, again, Representative Wagner raised Scope 3 emissions. And Scope 3 emissions is in that proposed rulemaking, is it not?
I believe it is, yes.
Yeah, thank you. So let me read you what the task force says about trying to do this. The gaps in emissions measurement methodologies, including Scope 3 emissions and product life cycle emissions methodologies, make reliable and accurate estimates difficult. The lack of robust, cost-effective tools to quantify the potential impact of climate-related risks and opportunities at the asset or project level makes aggregation across the organization's activities or an investment portfolio problematic and costly. The need to consider the variability of climate-related impacts across and within different sectors and markets further complicates the process and magnifies the cost of assessing potential climate-related financial impacts. And finally, the high degree of uncertainty around the timing and magnitude of climate-related risks makes it difficult to determine and disclose the potential impacts with precision. That is what the Carney-Bloomberg task force says about trying to deal with Scope 3. So how in the world could the SEC have that in a rulemaking?
Again, I would have to refer you to the policymaking division.
Well, we'll do that. But how do you think, as an enforcement officer, you could take that to court? Challenging? Yes or no?
Again, I haven't read the report you're talking about, and I tried to...
Well, just read the proposed rulemaking that your agency's put forward, because it has the same philosophy, that this is a no-brainer and we need to do it to save the planet. So I'm asking you, can you enforce something that's vague, not reliable, not accurate, not timely, not comparable across industries, not comparable within industry, and not agreed upon by the accounting profession, those companies, or your staff? Pretty hard to take a case to court on that. Yes or no?
Again, I haven't looked at the report you're talking about, and I would I will share your concerns with the policymaking divisions. I tried to explain how we go about our enforcement actions.
Well, we're grateful for your enforcement service, and a lot of us on both sides of the aisle share the greenwashing concerns about misleading advertising by the biggest fund companies in the country. And we've studied that. We've heard testimony here about funds that allege are sustainable funds, but they actually look just like an S&P 500 fund but charge a higher fee. Is that what you've seen in some of your research on litigation?
We've seen that type of misrepresentation certainly in the matter that we talked about today. And again, I can't talk about other investigations that we're looking at into this space, but it's a concern when investors are not getting accurate information about what they're investing in.
Well, we thank you for your service to the people of New Jersey and now the people of the United States. Yield back.
Thank you.
Thank you. I think we all agree with the gentleman from Arkansas that clear standards are helpful. That's why I'm pleased to recognize the gentleman from Connecticut, Mr. Himes, who is the author of the Insider Trading Prohibition Act, which would codify and define insider trading. He is also the chair of the Subcommittee on National Security, International Development, and Monetary Policies. Recognized for 5 minutes.
Thank you, Mr. Chairman, and welcome, Director Grewal. And since the chairman teed me up for it, I will just note that in your written testimony, you say something very important. You say many Americans' trust in our financial markets and institutions is at near historic lows, quoting a Gallup poll. And then you go on to say, some believe that there are two sets of rules, one for the big and powerful and another for everyone else. That, I think, is both accurate and should concern, as I think it does people on both sides of the aisle here. So maybe I will just point out that that my insider trading bill, H.R. 2655, has now passed 2 Congresses, been included as an amendment to the NDAA, and it is time for it to become law. I am grateful to my Republican colleagues for making that bipartisan. Now, of course, we just need to get it through the United States Senate. I do appreciate your agency's assistance on that. I think it's important, given all that you have to do, that your enforcement people not spend a whole lot of time slicing and dicing Newman and Salmon, and that we finally do what we should have done long ago, which is if we're going to prosecute people, make it clear why precisely we are prosecuting them. But I do thank you and your agency for the assistance there. In my remaining time, Director, I've been focusing quite a bit, as I know you have, on cryptocurrency. And so, question for you, I've watched the ramping up of both people and resources on that side. I wonder, given the list of names, Tether, Voyager, Celsius, et cetera, of where we've seen really substantial either declines, bankruptcies, or questions around fraud, do you have the resources and the expertise that you need? Even if the answer to that question is yes, what more does the SEC need to in this maybe pause in excitement around cryptocurrency to make sure you're in a position to enforce? There's a second question I want you to ask that may be a little bit less comfortable, which is I'm pleased that the Congress is really working hard in educating itself on cryptocurrency and even moving some legislation. So this may not be a comfortable question for you, but since you've got the panorama of misbehavior and make the decisions about when to enforce and not to enforce, what advice would you give us as lawmakers for what should be at the top of our priority list in terms of legislating?
So I'll start with the first question on resources. Certainly resources are an issue across our division and across the agency. We're still not up to the numbers we were at prior to 2016. The additional resources in the crypto asset unit will help. They include litigators because a number of these cases are in court right now and are a drain on our resources. But the expertise is not within enforcement alone. We rely on FinHub, which is our strategic hub for finance and innovation and technology. And we rely on other divisions and their expertise. So it's a team effort on these issues as they touch the other divisions. I think we will need more resources moving forward, but for the time being, I think this will allow us to focus on all of the risk that we're seeing right now in the market that you alluded to in your question, and continue our investigations at pace to make sure investors are protected and those that aren't compliant with our laws come into compliance. With respect to the second part of your question, I'd be happy to sit down with your staff and talk through some of the issues that we're seeing in a different setting and go through some thoughts that we may have on that. I just need to consult with others because, again, it's not just an enforcement issue alone.
Well, let's talk for a second. It's a nice opportunity to address a lot of people who are thinking and working about this. So let me push you on that a little bit. Obviously we're doing a lot of thinking here about how you divide the world between SEC and CFTC. So maybe I don't have a lot of time, but talk a little bit about partnership, cooperation, how's that going? Anything that, again, as we draft legislation, we should bear in mind?
So not just with respect to crypto, there are a whole host of other spaces in which we work well with the CFTC, and we run into them where issues may touch both of our remits, and we know how to deconflict. We know how to work in parallel. We did that with the collapse of the Archegos family office. They brought charges that touched on their remit. We brought charges that touched on our remit. The SDNY brought criminal charges. We did that with the collapse of Infinity Q and other cases. So we know how to work with them. We work well together, and the chair has alluded to some areas in which we could use additional guidance, and I would defer to the chair's office on those issues.
Thank you, Director. My time has expired.
Thank you. We now recognize the gentleman from Minnesota, Mr. Elmer.
Thank you, Mr. Chairman, and Ranking Member Huizenga for hosting this hearing today. Mr. Grewal, you frequently acknowledged that public trust and confidence in our capital markets has eroded. In fact, on October 13th, 2021, you stated, quote, "The decline in trust undermines the investor confidence needed for the fair, efficient, and orderly operation of our capital markets. Put simply, if the public doesn't think the system is fair, they are not going to invest their hard-earned money." Close quote. I agree. But time and time again, you place the cause of blame for this erosion of trust almost squarely on the shoulders of industry participants and companies. Mr. Grewal, the SEC is in no way blameless here. Chair Gensler's political regime at the SEC, carried out by its Division of Enforcement, has been characterized by a focus on using enforcement to expand SEC jurisdiction at the expense of public resources, public investment in our country, and public trust in our markets. It seems clear to everyone, except maybe those at the Commission, that the SEC is not regulating in good faith. Although many sectors of the industry have grappled with the SEC's politicization of regulation over the last 14 months, it can be seen most clearly when it comes to the digital asset industry. Take, for example, industry sweeps. As you know, industry sweeps are not novel to the digital asset industry. They are a series of voluntary document production request letters as a regulator sends to everyone in a given industry who is similarly situated or is involved in the same type of activity. Mr. Grewal, does the SEC Division of Enforcement do industry sweeps?
We do industry sweeps from time to time when we have indicia.
Thank you. The answer is yes. I reclaim my time. Are there currently any industry sweeps underway?
So I can't talk about investigations.
You can't talk about it legally, or you won't talk about it?
It's our policy not to confirm or deny investigations.
So you won't talk about it. All right. What do you do if a company, sir, cannot respond to a sweep letter because they're not in your jurisdiction?
If we issue a voluntary request for information, there's not much we can do. We can proceed with the subpoena and then a subpoena enforcement action.
So you do extra jurisdictional requests then?
Voluntary requests are just that. They're voluntary. They're an important part.
Again, sir, I'm not asking about the request now. I'm asking about the people you direct those to. There are some that would be within the SEC's jurisdiction. There are some that are not. My question is, and I think you've confirmed it, that you do industry sweeps to extra jurisdictional market participants, people you do not have enforcement authority over.
We subpoena individuals and witnesses who may be in the market participants.
Are they within your jurisdiction and outside of your jurisdiction?
We're not limited by our jurisdiction. When we're collecting evidence, we follow the evidence wherever it leads and to whomever it leads. There may be someone who doesn't work in the industry who might have information.
I would say, sir,
go after them.
I would ask you, so you do extra jurisdictional work. Some would argue that that's not appropriate. But Mr. Grewal, has Chair Gensler ever directed you, or to your knowledge asked any of your colleagues, to make it a bloodbath for companies who don't respond to a sweep letter, which are voluntary?
No, that's not happened.
Interesting. We've become aware that Chair Gensler has in the past directed the Division of Enforcement to send a sweep letter to a particular sector of the crypto community designed to jam them into a violation that is allegedly unconstitutional. And if any company does not respond to said sweep letter, which I'll reiterate, as you've said several times, are supposed to be voluntary, then the SEC would make it a, quote, bloodbath for them. If true, I imagine such a tactic would significantly erode trust between the public and the SEC. Here's the problem. The SEC isn't interested in clarifying what areas of the crypto industry fall under SEC jurisdiction. We know that because FinHub, that you've referred to, the SEC division focused on crafting crypto regulation, has essentially dissolved under Gensler. Nonetheless, while abandoning good faith attempts to clarify how the Commission's existing authority applies to digital assets, the SEC is hell-bent on expanding the size of its crypto enforcement division and using enforcement to unconstitutionally expand its jurisdiction. Under Chair Gensler, the SEC has become a power-hungry regulator, politicizing enforcement, baiting companies to, quote, come in and talk to the Commission, then hitting them with enforcement actions and discouraging good faith cooperation. Understand, sir, there is a new day coming. Thank you. I yield back.
Now we recognize the gentleman on the screen, Mr. Vargas from California.
Thank you very much, Mr. Chairman, and thank the ranking member for this hearing, and in particular, thank you, Director Grewal, for being here. Director Grewal, last year Congress passed my ESG Disclosure Simplification Act that would require public companies to disclose certain environmental, social, and governance ESG matters in annual filings with the Securities and Exchange Commission. Investors in my district and across the country have increasingly been demanding public companies disclose ESG material that is material and inform their market activity. As a result, the SEC has received thousands of comments from economists, market advocates, and investors requesting that companies and banks file ESG disclosures to protect investors, ensure fair, orderly, and efficient markets, and facilitate capital formation. Therefore, I'm glad that the SEC has proposed an ESG rule that clarifies reporting standards, quote, to promote consistent, comparable, and reliable information for investors concerning funds and advisors, incorporation, and environmental, social, and governance factors. Director Grewal, can you please describe how your division is positioned to enforce this rule once implemented and ensure that investors have access to standardized ESG disclosures?
Thank you, Representative Vargas, for the question. As I mentioned earlier, the rulemaking is done by different divisions than mine.
Right.
It's impossible for me to talk about climate enforcement because, pursuant to those rules, because they haven't been adopted and the version of the final rule hasn't been put out. What I could tell you is that we have seen, from the enforcement perspective, that ESG issues are certainly important to investors, that greenwashing is occurring. We're using the tools available to us, the anti-fraud provisions of the securities laws, to hold bad actors accountable, whether they're issuers who are misstating making material misstatements about climate risk or about their ESG strategies, or advisors who are doing the same thing. We're holding them accountable under the Advisors Act.
So you've been using the anti-fraud provisions, but they do seem a little bit inadequate. I think that's why they're coming up with the rules. Is that the reality?
The rules, again, I would have to refer you to the rulemaking divisions, but I think you mentioned it at the beginning of your question. It's to have in one format consistent, comparable information when issuers are speaking on these issues or when advisors are speaking on these issues. And so that consistency will help us evaluate compliance, and if people are lying about their compliance with those regs, then certainly that's something we would look at. But it's hard to talk about the rules before they're proposed or before they're made final.
That's a good point. But now you did talk about lies, and you can enforce lies. In fact, you said that people have already confirmed that, or companies have already confirmed that they had lied in cases. So you were able to go after them under the anti-fraud provisions with respect to ESG.
That's right. We've brought some recent actions both in the advisor space and against issuers.
Well, I was a little curious here when you said that obviously you have the experts in the law. Those are your lawyers, and you do have very good lawyers. But you said that you rely on experts for the environment or ESG matters outside of, I believe that you said outside of the SEC. Who are, I mean, are those regular experts that you would use in litigation, let's say for, well, you wouldn't in medical purposes, but an attorney would rely on experts bringing their case. Is that what you mean? Is that the type of expert you're talking about?
That's exactly right. That's something we frequently do in this space and other spaces where we need litigation experts, where we need to qualify experts for court proceedings where we need to produce expert reports on litigation-related matters. That's right.
Well, I would commend you again for working in this ESG space. I think it's very important. I do think that many investors see that as material, which is what matters. And again, I appreciate you doing that. Lastly, I do want to comment very briefly on the issue of cryptocurrency. I can't believe that you're getting criticism for an industry that basically has almost collapsed and has taken so many retail investors down. I appreciate what you're doing. I know you need more people in that section, and I'm happy to support you in that. I have 13 seconds left, 12 seconds. And in that, I just say again, thank you for showing up. We appreciate you, and I think you're doing a hell of a good job. Thank you.
Thank you.
I thank the gentleman from California for his observation and recognize Mr. Davidson of Ohio for 5 minutes.
Thank you, Chairman. Thanks for finally holding this really important hearing. And thankfully, our colleague, Mr. Vargas, doesn't give investment advice, particularly with respect to the crypto market. And thankfully, we can clarify some of the things here. I just want to clarify, I think enforcement's a very important function for the SEC, and so thank you and those who are committed to doing it honestly and ethically as part of our government at the Securities and Exchange Commission. But fundamentally, are digital assets exempt from treatment as pump and dump scams?
No, we've seen pump and dump schemes involving digital assets.
How many enforcement actions have been taken by the SEC?
Again, I'd have to provide you that information at a later date.
I'd appreciate that. And frankly, I'm curious why some of the biggest ones that look from an outsider, like probably pump and dump scams, don't get targeted. Why are they selectively, seems like some things are given a pass and some things are targeted. What's the criteria for targeting?
There's no selective prosecution. We have to balance the risk that we're seeing with the resources that we have, and we have a number of investigations.
So maybe the big ones take too many resources to go after, so you just say, well they'll get a pass?
No, I'm very proud of the work that the 1,300 women and men in my division do. They don't give people a pass, they hold violators accountable.
Okay, let me run a hypothetical scenario by you. Say an SEC official gives a speech at a conference, and the official begins, of course, by stating that, quote, their views are their own and not necessarily those of the commission. Anyone who's ever heard an SEC office official speak would know that this is standard, and they would not interpret the speech as legal guidance. However, let's say that the SEC official consulted SEC staff and perhaps even ethics directly to assist them in writing speech or giving guidance. Under this scenario, would the written speech still be considered personal views of the individual and not views of the commission?
Respectfully, I can't answer that right now because that hypothetical is a real scenario that's playing out in litigation.
Oh, what litigation would that be?
That would be the Ripple litigation.
Ripple XRP. So is it true that Director Hinman submitted his speech to ethics for approval?
Again, I can't comment on pending litigation.
Okay. Director Grewal, we talked a little bit about really the SEC. Last year, the SEC made a, quote, a no-action enforcement announcement regarding the amendments to proxy advisor rules from July 2020. Further, the Financial Services and General Government Appropriations Bill that's moving through the Rules Committee this week prohibits any funds from being used to implement these proxy advisor rule amendments. On July 13th, Chair Gensler even announced that the SEC would consider adopting different amendments to the rules governing proxy voting. Given that regulation by enforcement is Chair Gensler's specialty, I find it ironic that the agency refuses to enforce the already settled proxy advisor rules. Here we have regulatory clarity and yet no enforcement. When it comes to digital assets, we have zero clarity, yet the Commission chooses to regulate by enforcement. Selectively, it appears, frankly. Can you please explain this Gensler paradox?
Again, I can't speak to the rulemaking. That's being handled by a different division, as is the exemptive relief that you...
The rulemaking on proxy advisors is clear. It's already the law. Why aren't you enforcing it?
So again, Our division doesn't engage in selective enforcement. We have over 1,500
So you're not, so
investigations.
you just aren't actively commenting because there's active enforcement going on of that rule?
I'm responding to the statement that we are selectively.
No, I want you to respond to my question. Is there active enforcement of the standing proxy advisor rule?
Again, I'm not going to talk about investigations that may or may not exist. It's our policy that investigations are confidential, so.
Well, the specific one, but are there actions to enforce the existing law?
We enforce the federal securities laws when we see violations. We have 1,300 women and men who investigate those violations. And when we make a recommendation to the commission and they agree with our recommendation to move forward with an enforcement action, we do. When a matter is settled, we recommend that settlement to the commission.
Okay.
We are doing everything we can to hold violators accountable. And so I have to push back because.
Well, I think
these are public
we'll
servants
disagree
who are trying to do
about
the right thing.
performance. I'm glad you're here. Director Grewal, as you know, U.S. capital markets boast nearly 41% of global equity and 40% of global fixed income. Needless to say, we have the deepest, most robust capital markets in the world. Was it that way prior to Chair Gensler taking over at the SEC?
I think the chair has constantly recognized how robust our capital markets are.
Well,
Given us
okay,
the
so it was that way
resources to do our
before. I mean, I think he's recognized it. So he didn't make our markets great. They were that way and continue to be that way despite his presence or maybe in spite of his presence there. Do you believe Chair Gensler will ever stop pursuing a social political agenda and weaponizing securities law?
The
or
time
would
of the
he object
gentleman
it?
has expired. But he's welcome to submit his question for the record, and I'm sure our witness will give him a good written response. We now recognize the gentleman from Illinois, Mr. Caston, who is the vice chair of this very subcommittee.
Thank you, Mr. Chairman. Thank you, Director Grewal. I want to ask a couple of questions, if I could, more in the investor protection realm. This is a little over the 2-year anniversary of the death of Alex Kearns from Naperville, Illinois. This was the young man who was told by Robinhood that he owed them $730,000, took his life after writing his parents a note saying that he didn't know how someone who only had $5,000 to his name was allowed to trade $730,000 of options. That story was soon eclipsed in the national zeitgeist by the GameStop hearings and getting into where were the incentives within Robinhood. And what emerged on this committee was that Robinhood is really this sort of near perfectly toxic brew of selling only to people where they have payment for order flow contracts, earning their revenue not as a fixed fee on those PFAF contracts, but as a percent of the spread, the bid-ask spread on the back end, and then relying on gamification. And so they just had these incentives to find the least sophisticated money in the market, connect them to the most sophisticated players, and then basically use gamification to put the whole thing on steroids. We've had a number of hearings in this committee. We've had a number of bills. I wonder if you could just speak for a moment about what the SEC is doing specifically around gamification and payment for order flow, because as I sit here, we still have not created the regulatory conditions that will protect, a future Alex Kearns from being caught up in this same toxic brew. Can you speak briefly to that?
First, I'm sorry to hear that about the constituent. It's a horrible, horrible story, and I've read about it. Gamification is a huge concern. Last year in the fall, we put out requests for information about gamification, and we're trying to gather more detail from people across the market to see how this practice exists, different perspectives on that practice, and my hope is that will help us inform next steps. From an enforcement perspective, I'm concerned when gamification crosses the line into a recommendation. If it does, and then it has, those folks have to comply with Reg BI. And so I see that as a potential avenue for us to get involved in that space, and we're concerned about it. And gamification also, I think, as we've seen, can be used for manipulative conduct, to further manipulative conduct, and so that's a concern from an enforcement perspective as well.
So you've touched exactly on my follow-up, and I mean, this format is horrible because we want to play gotcha and get zingers on the record, but at least as I sit there from my perspective, I have no idea how you could honestly say you were looking out for the best interests of your customers if you are using gamification to recommend stocks, and if you are only relying on payment for order flow off-takers, right? I mean, by definition, you are not looking. And can you say anything affirmatively that we know this? And it hurts me because we're 2 years in, and what seems to be obvious, we're still waiting for a hearing and a ruling. And meanwhile, you know, the companies like Robinhood continue to make a lot of money from what seems to be not looking after their investors' best interests.
So again, I can't talk about specific entities or individuals or firms that we may or may not be looking at. I could tell you that digital engagement practices more broadly are a concern for the chair. We've started this information gathering last fall on this issue. Perhaps that will inform future rulemaking. I've shared with you how I think it impacts enforcement. It's something that we're very concerned about, particularly with Reg BI, how it intersects and could constitute a recommendation. And then on the manipulation side, how it could be used in furtherance of manipulative conduct. And it could have horrific consequences as well, as we've seen in the case that you highlighted.
I know we've only got 50 seconds left here, but a lot of those same factors seem to be, I mean, the crypto rise and crash looks an awful lot like the meme stock rise and crash. It's driven by a lot of the same zeitgeist. It again looks like the unsophisticated players taking charge. Leaving aside that you can't tell us exactly what you're doing on the gamification and PFOF issue, is crypto the same way, or are we going to have to at some point clarify whether you or the CFTC has authority over crypto before we can make sure that we're protecting those investors there?
We're using, Congressman, our authorities to investigate and bring actions against those who violate our laws, whether they be the anti-fraud provisions or other aspects of the securities laws.
Are you satisfied you have the resources to do that?
Well, I could always use more resources, but we're making the best with the additional 20 slots, and I'm hopeful to get the 125 additional slots that we've asked for.
Okay, yield back. Thank you.
Thank you. Now recognize the gentleman, but before I do, I should point out votes have been called. Some 413 members have not voted. Some 7 minutes and 13 seconds remain on the clock. We may be able to conclude the hearing before we all have to go to vote. I will announce when we're down to 110 people who haven't voted. And if we don't get concluded, we'll reconvene after the 2 votes. I recognize the gentleman from Indiana, Mr. Hollingsworth.
Director Grewal, thank you for being here today. I know you've been asked many questions, some of which are inside your bailiwick and others perhaps outside. I want to ask something that I believe is very, very germane to your daily job: enforcement. Do you agree that there's a difference in the legal authority and legal obligations you have to enforce rules/regulations promulgated by the SEC as compared to guidance from staff through staff accounting bulletins?
Excuse me, staff accounting bulletins are exactly that. They're guidance. They're guidance that OCA offers on an issue where there's been some question, and it's their
Is there a difference
guidance
in
for
the
industry?
Understand the definition of staff accounting bulletins. Is there a difference in the enforcement or level of enforcement or the actions of enforcement or the likelihood of enforcement, these things under your control, between rules and regulations promulgated versus staff accounting bulletins, question mark?
Again, we wouldn't be involved in the enforcement of violations of staff accounting guidance.
So for clarity, there's no enforcement that you would bring based on that which is promulgated or put forth through staff accounting bulletins alone.
Again, every violation is facts and circumstances. I don't know what else might be in that hypothetical situation.
That's not a hypothetical situation. I'm asking. That is not a hypothetical situation. There's no example here. I am asking you to repeat exactly what you just said. We do not enforce. This is what I heard you say, and I just want to make sure that you repeat it. We do not enforce violations, quote-unquote violations, actions in contravention, I should say, to staff accounting bulletins, question mark. Is that what you said?
So I said staff accounting bulletins are guidance. We enforce violations of the federal securities laws and the rules and regulations promulgated from those laws. Staff accounting guidance or staff accounting bulletin may intersect with another violation or may be part of a fact pattern.
But it alone is not law.
Standing alone, no.
It alone is not law, and you are enforcing the laws of this country, correct?
The laws and the rules and the rules and regulations that are promulgated from those laws.
Great. As you know, I wrote a letter to the SEC last week regarding SAB 121, signed by a majority of committee Republicans. That letter it is, not SAB 121, raising several concerns with the policy in the bulletin and the absence of a transparent process from SEC staff. Very specifically, again, does SAB 121 legally require counterparties that participate in the activities included in the bulletin to adhere to the bulletin? Legally require them to do so?
Again, it's guidance, and I don't mean to push off these questions on my other divisions, but that's the Office of Chief Accountant that promulgated that.
I thought it was your office that enforced these things or failed to, or does not enforce these things.
This staff accounting bulletin was promulgated by the Office of Chief Accountant, so I would direct you to that office about how they're ensuring compliance or how they're pushing that out.
If someone refers you an activity that is in contravention to SAB 121 and requests that you enforce it, what is your response to that?
It would depend on the facts and circumstances of what's referred to us. If there are other, it would, again, depend on the facts and circumstances of what's referred to us.
And those facts and circumstances would be whether they violated other actual laws or whether they violated this guidance, question mark.
It could be part of a larger violation. I just can't, engage in
But
this
standing alone, you don't believe SAB 121 or other SABs promulgated are law and can be enforced by virtue of the law?
Again, their guidance.
Understood. So how does the SEC plan to address the implications of accounting firms that require organizations to adhere to that guidance?
Again, I'd refer you to the Office of Chief Accountant that deals with those issues and deals with the accounting firms.
Well, what I've heard you repeatedly say, which is very impactful, and I appreciate your candor, is that these staff accounting bulletins are not law and cannot be enforced as though they were law. This is something that continues to concern many firms that interact with our office, many Americans that believe in contravention to how we create laws in this country, staff accounting bulletins are carrying the force of law instead of going through the normal process by which we promulgate rules. I appreciate your candor about the difference between those two and the activities that you can and cannot undertake in enforcement as it relates to those two. Thank you, and I yield back my time.
Thank you. I'll point out that we're trying to organize a hearing to deal with accounting and auditing issues. We hope to have the chief accountant to the SEC, the chair of FASB, and the chair of the PCAOB. Stay tuned. Now I recognize the gentleman from Wisconsin, Mr. Steele, and I believe you'll be our last question.
Last but not least, thank you for being here, Mr. Grewal. Appreciate it. We've covered a wide range of topics. I want to cover 3 in the limited time that I have. First question, can you tell us about any enforcement actions regarding proxy advisors that you've taken during your tenure at the SEC?
I'm sorry, I didn't hear the first part of your question.
No worries. Can you tell us about any enforcement actions regarding proxy advisors that you've undertaken during your tenure at the Securities and Exchange Commission?
So it'll be a year for me next week, but I'd have to go back and consult with our office on that, get back to you on that information.
That would be terrific. Is it your view that as proxy advisors are not a proxy solicitation under the 34 Act, that you'd need an action by Congress to further oversee proxy advisors, or do you think you have current authority to review proxy advisor firms in your current position?
So again, that's something I'd refer you to our policymaking divisions who are handling the proxy advisor rules and the changes there too.
Okay, I'm pretty concerned with the changes that were just recently made. I think it was a mistake to strike down the Clayton proxy advisor rules, not under your realm of jurisdiction, but I do think it's relevant as we think about the power that these two proxy advisors that control roughly 97% of proxy advice in this country play. I think it's a very reasonable place for the SEC to be providing substantive oversight over. Let me shift gears. I want to echo my colleague Mr. Huizenga's comments regarding the Division of Enforcement, the historically that adopted a historically broad understanding of what the term dealer means. I listened to your answers, and so I won't ask you my questions, but I just would note, and I think I echo my colleague here, that I want to caution that these broad definitions and aggressive enforcement approaches come with a real cost, and specifically classifying everyone as a dealer could chill investment, in particular in small public companies. And my concern is that that'll hurt innovation and competition. And so I want to ask you a question because I think it was covered previously. I know there's ongoing litigation in that space. Let me get to my final topic here, and I know Ms. Wagner commented on this. And so, Mr. Grewal, I'm really concerned about the SEC's climate disclosure proposal. You would be in the enforcement arm at the SEC. And American businesses struggling with high inflation, with labor costs, supply shortages, mountains of red tape, and while at that same time, we're watching the SEC seems determined to push companies to spend scarce resources on disclosure of what I view as non-material. If it's material, disclose it. Non-material climate change-related items. And so I have two concerns. First, the proposal itself. Public companies already disclose material information to investors. Enforce issuers to disclose information that may not be material. Comes with great costs and little benefit. Second, and this is where your office comes in, I'm concerned with what this rule would be difficult to implement and would probably fail to achieve its desired effect. And so one of the trickiest aspects of the climate proposal concerns Scope 3 emissions, the downstream emissions impact, and the issuers that will be expected to report on this topic. So could you walk through how your office intends to handle compliance cases related to Scope 3 emissions disclosures?
So again, Congressman, I'll refer back to an earlier answer I gave on this specific question. It's impossible for me to talk about how we would enforce this rule, which has yet to be finalized and yet to be adopted, and we don't know yet what it will look like. I tried to explain how we, bless you, I've tried to explain how we've gone about dealing with these issues using our existing authorities.
So let me appreciate that. Maybe I can get a little more clarity then. Does your office have expertise in climate science?
So as I mentioned earlier, where we need expertise for our enforcement actions, for example, a climate-related matter that we're prosecuting now in court, we've gone out and gotten that expertise in litigation.
So what would be the cost structure of that in the case you just referenced?
It would be the same with any litigation, any litigated enforcement action where we go out and retain experts within the rules that allow
These would be individuals probably charging in the neighborhood of $1,000 an hour, rough estimate.
We could provide you that information. I think
that would actually be helpful, because here's my concern: is if we take the rules, if we assume they're currently implemented, it would fall to your office. I think it would involve hundreds of individuals that would be required to have very specific climate expertise. We could judge whether or not they're politically motivated. It would cost thousands of dollars not only for the SEC, but also for these companies to comply, rather than allowing these companies to build jobs here in the United States of America. I know we're out of time, Mr. Chairman. Recognizing there's votes, I will yield back.
Thank you. Some 341 of our colleagues have yet to record their votes, so it looks like we can conclude. The ranking member is recognized for 1 minute for a concluding statement.
Mr. Grewal, while I'm appreciative of you being here, this is too little, too late, in my opinion. And frankly, on the too little, I would observe that neither side really got answers from you. There was a lot of need to talk to somebody else, need to talk to a different division head. It causes me to wonder how we are going to get those answers. And it's true, maybe the other side's a little more polite about it, but we need to have these answers because this is our constitutional duty, as we, according to the Constitution, are the purse bearers for the U.S. government, meaning you have to come to the House of Representatives for appropriations, and this committee works with our FSGG counterparts on the Appropriations Committee to deal with the policy and the funding of it. So we better start getting some answers when you are, especially as you're coming up and asking for more resources. I do want to correct one thing on the ALJ situation. The breach happened in 2017. The SEC disclosed the breach in April of 2022, the statement, but according to the Wall Street Journal, the breach was discovered in fall of 2020. That lack of time of being transparent and open and honest with this committee and with the public is problematic, and my time is up.
Thank you. I want to thank the witness for joining us, enlightening us with his comments. There have been a number of comments of our colleagues about the need for definition. No definition is more important than to define security, since that's what the SEC does. Congress really hasn't acted. The courts have acted with the Howey test, which was not focused on digital assets since it was written in the 1940s. But the fact remains XRP, I think, clearly is a security, and we need enforcement not only on those who issued the unregistered security, but those who provided in exchange for it. Likewise, it would be good to have a definition of ESG, but right now companies and mutual funds put forward their own definitions of ESG and promise the investors that they will follow them. When they don't, that's when enforcement is called for. It is not enforcement by regulation to take a security, which it clearly is a security, I believe, under the Howey test, and to enforce our rules against it. Of course, more clarity would be helpful. My Republican colleagues have said that there's no formal rule that has been adopted on ESG. We understand that. You still need to go forward, and it's my understanding that you're going forward in those areas where they're not meeting their own stated standards. This hearing is adjourned.